Welcome, everybody, to episode 3 of Big Data, Big Issues. My name is Sheldon Kreger, and you can find out more about me using the link to my LinkedIn profile, or you can search for me online. My topic today is the Washington Privacy Act, Shortcomings and Solutions. And this is a follow-up episode to episode 2, where I discuss the Washington Privacy Act in regard to its contents and the politics kind of surrounding what happened in 2019, how it failed to pass. I'm optimistic that in 2020 it'll be reintroduced, but I'm very uncertain as to whether it will be passed or not because of the complexity of the political problems as well as the high stakes. I think that there are going to be some significant challenges to getting this legislation through. Today, what I want to do is actually tackle some specific sections in the Washington Privacy Act that I found to be problematic and needing a lot of work, and explaining the problems, giving some examples, and providing some solutions. The disclaimer here, of course, is first of all, as usual, these are my own personal opinions. They don't represent that of my employers, past, present, or future. And I'm not a legal expert, so this is not legal advice. It's strictly for educational and entertainment purposes. And furthermore, because I'm not an attorney, my opinions here are not necessarily well informed on the legal side in terms of, are the solutions that I'm proposing legally feasible? This is strictly my perspective as a professional in the big data space. In a perfect world, with a fully functioning legal system, these are the kinds of restrictions that I'd like to see surrounding this law and these practices, regardless of what's necessarily politically feasible or legally feasible as well. So with that, let's start with just a very brief context about why the Washington Privacy Act is so important. As we are well aware, there's an exponential growth in data collection and analysis due to the affordability and implementation of big data technologies. And there's also a growing consumer awareness about privacy problems. There's been, this is October 2019, October 27th specifically. And we already have the GDPR from the European Union that's been in effect, I believe, for around a year now, and as well the California Consumer Privacy Act, which comes into effect early next year. So organizations are already kind of scrambling to meet the requirements of this new legislation, and Washington's kind of trying to get their say before there's a national bill. It's actually specifically stated in the Washington Privacy Act that we understand that legislation at the state level is going to have an impact on the standards that are set at the federal level. And so this is very high stakes legislation for all of these issues. And on top of that, there actually is a bill being thrown out there, I believe, from Ron Wyden. Don't quote me on that, from Oregon, a federal bill that's going to be thrown out there next year. So this is all very, very hot topic right now. The primary problems, the primary regulations, I guess, that this legislation seeks to tackle are the problems of the right to be forgotten, so to speak. So if a consumer finds out that a company has collected data about them, then they want to have the ability to edit that data or to request the data be removed, and also view that information that's been collected about them. And this is ongoing legal battle, especially in Europe as well as in the United States. And the reason this is important is because of the amount of political behavioral data that's being collected for consumer profiling, used primarily for targeted advertising, and but spread across the corporate environment in a very rapid and broad manner. So, for example, one company may collect data and then sell that data to a data broker, and another company may purchase that data and use that for their own consumer profiling purposes without necessarily legitimate consent from a consumer. And this is and there's no way to undo that once it's been done. And so the WPA is very much trying to create some responsibility around that problem. In addition to that, it has specific information about where the chain of responsibility lies for who's liable for ensuring that data removal requests are completed. Is that supposed to be the organization that collected the data? Is it the organizations that purchased the data or processed the data? We'll go into that in a little while. It also has a section specifically on facial recognition technology, both corporate usage and usage by law enforcement. And it also creates some important exemptions for the healthcare system and for researchers, as well as the government of the state of Washington when they're collecting data about citizens. So very briefly, this is covered in more detail in the previous episode. However, it's very important to understand the difference between data collectors and processors in the context of the WPA. A controller means a, quote, the natural or legal person which, alone or jointly with others, determines the purposes and means of the processing of personal data. And a processor, in contrast, is, quote, means a natural or legal person that processes personal data on behalf of the controller. So an organization may collect data and then determine what they want to do with that. And that would be the data controller. They are the ones who determine what kind of analysis is done and what they use with the information that they gain about the consumers or about the citizens or whatever. And then a processor is another organization, or it could be internal to the same controller organization. The processor is the legal entity that handles the actual doing the calculations. It's a little bit unclear whether if you're using a cloud service provider that's operating a database for a data controller, are they a processor? It's kind of unclear in the bill, but essentially some kind of external company that handles doing data analysis or maybe storage or working with the data in some other regard, but not having necessarily any kind of say on what the data is used for. And what's interesting about the WPA is it really indemnifies the data processors to a large degree, which is something we'll talk about. So the legal liability really falls to the data controllers. And what that means is that when a consumer finds out that their data has been collected, or when they give consent to have their data collected, they do that with the data controller. And then if they want to make a delete request, for example, the data controller is responsible for making sure that that data gets deleted from all the systems that have been working with that data. So that would include notifying any data processors that were using that data that the delete request needs to be fulfilled, as well as any data brokers. And then it's a little bit unclear what happens once the data broker gets a notification. If they've sold it to other companies, where's the chain of responsibility? How far does this go? I think it's a little bit unclear in the bill. And the other issue here is that the processors are just completely indemnified. As long as they do what the data brokers tell them to, then they're more or less off the hook based on what I can read, my reading of the bill. The solution here, in my opinion, is that the data processors ought to have some responsibility for the data, specifically in the context of working for foreign controllers. So in the United States, because this is state level legislation, this cannot apply to interstate commerce. So if a data processor or if there's any interstate trade of the data, then the legislation is just not going to apply. And that's something, unfortunately, that we can't handle here in Washington. It needs to be handled at the federal level. However, we do have authority, my understanding, at least, and maybe I'm wrong about this, but my understanding is that we do have control for international commerce. So if a data controller from a foreign country is using a data processing organization, it's like a software company here in Washington, then I believe that the data processors ought to have some liability for what they're doing with that data and what the intent is of the controllers that they're working with. Because what happened, and we'll revisit this again, but what happened in 2016 is there was interference by foreign agents, especially in Russia, a very well-organized operation to interfere with the election and create political turmoil within the United States, using data processors here in the United States, specifically Facebook and other social media organizations, where they were able to purchase data and ads and run social media campaigns to target specific kinds of individuals and then dictate political messages through the social media to those groups of people. And I believe that for examples like this, the data processors need to have some liability for what foreign controllers are doing with the data they're working with. The next issue I see in this bill is in regard to the facial recognition software piece. The bill is split into regulations for corporations and regulations for law enforcement. So first we'll discuss the corporate standards, and this is a quote from Section 14.4 of the WPA. Controllers must gain consent from consumers prior to deploying facial recognition services in physical premises open to the public. The placement of conspicuous notice in physical premises that clearly conveys that facial recognition services are being used constitute a consumer's consent. So there were actually a number of people in the public testimony, a number of organizations that spoke out against this specific part of the legislation, because it's virtually a red carpet for corporations to lay out widespread facial recognition software programs and use this in the public. And the intent of the bill was not to do that. It was really to legislate and to place regulations so that people have to opt in when facial recognition is being used by a corporation. Under this specific section of the bill, what this allows is, let's say I go to a grocery store where they want to do some facial recognition on me so that they can track my consumer behavior and maybe send me some targeted ads. This is a very, very vanilla ice cream kind of example, but very common. And let's say that they wanted to do this so I don't have to use a loyalty cards or a phone number at the checkout. And also they could track my behavior in the store so they could see, well, maybe I pick up a box of name brand cereal, but then I pick up a box of non-name brand cereal and I choose that one. They can do really, really specific analysis of my behavior if they're tracking me all the way around their store. And under this legislation, they could just put up a sign in the store that says, hey, you're under surveillance. We're using facial recognition technology. And by just walking into our store, you're giving consent. Problem is, there's no way to leave your face at home. There's no way to opt out. And if every grocery store in Washington started using this kind of thing, which is very likely all the major grocers or a lot of companies would start using this technology in different contexts, there would virtually be no way for a consumer to opt out, because there would just not be public spaces available where there's no alternatives, alternative places to shop, for example. So this would be like a very, very false choice. And furthermore, I think the premise that putting a notice up constitutes consent is extremely problematic, even more problematic than clicking on a privacy notice checkbox, agreeing to a huge legal document when you're browsing the web. That's already bad enough, but just saying that showing up at a specific place at a specific time and probably seeing a sign that's been put up as consent is just absolutely a joke to me. The solution, continuing with this, it's not just about what happens when you go out in public. The bill only addresses kind of that situation. However, there are instances where employers themselves want to use facial recognition software for their own to their own ends. Specifically, and a specific example of this would be a piece of software called HireVue, which I read about earlier this week. There's now been over 1 million job interviews conducted with HireVue software. Companies, if I remember correctly in this article, like Goldman Sachs, a number of big companies are using this software. And what it does is you set up a video camera during a job interview and point it at the face of the person you're interviewing, and the software does biometric analysis of the job applicant during their interview, and then it comes up with a score to tell you virtually how similar this person is to the employees that you think are good employees at your company, and whether they're going to, and then you can use this to make a determination on whether they're going to be a good fit for your team and whether they're going to be able to perform well on the job. This is pretty scary, I think, just kind of gut feeling. I think a lot of people hearing about this are absolutely terrified. And I know personally that having this kind of analysis done on me during a job interview would make me extremely uncomfortable. And the WPA does absolutely nothing about this kind of technology. Some additional problems with this particular example is that the applicants would have no way to prepare for the job interview to impress this kind of technology, because the company keeps the way the technology works in a very secretive black box. So there's no information about how you could prepare to do well in a job interview in the context of this biometric analysis. And therefore you have no way to sway the outcome of that analysis. It's literally proprietary software that's highly secretive, where the characteristics of what makes a good employee versus a bad employee are not publicly known. And there's no way to prepare or influence that. And I think that's just really unfair to job applicants. The final problem I'll mention here is that this kind of technology reinforces inequality, because it by definition, it prefers applicants that are similar to existing employees at the company where the interview is being conducted, because fundamentally the technology works by saying this company is working on behalf We're creating a biometric profile of your existing employees who you think are your best employees, and then we're going to use that to create matches from your applicant pool. And so you're really reinforcing the culture of your company into your hiring pool, which is by definition a discriminatory practice, in my opinion. The solution in the corporate context is, first of all, consumer consent to surveillance ought to be substantiated more thoroughly. Again, putting up a sign and saying you're under surveillance does not constitute consent, in my opinion. I believe there should be a full ban in public spaces for corporate surveillance, facial recognition usage, because data can be incidentally collected without any kind of oversight. So even if there was some kind of way to allow consumers to consent to this in a legitimate manner, the truth is that when you have cameras pointed everywhere, you're going to be collecting biometric data on people that have not consented. There's just going to be a lot of incidental collection in that regard, and I don't think there's going to be there's not going to be any transparency about that happening, and there's going to be no way for the government to reasonably enforce that that's not going on. Another solution I'd like to see is an expansion of the definition of facial recognition software to all biometric recognition, which would include voice analysis, palm analysis, fingerprints, there's all kinds of different biometric data and these algorithms and surveillance technologies are growing at a rapid rate, not only in accuracy, but in the way that the fundamental ways that they work and the kinds of biometric identifiers that they use. This bill needs to be future-proof to address those technologies. Last solution I propose in regard to corporate facial recognition is biometric analysis should never be used as the sole determination of an outcome in situations of high significance. That's a mouthful, and you can hear my attempt at legalese here. But the problem is that what this really means is, in the context of an important decision about your life, for example, approving a loan or whether or not you're going to get a job, there should not be biometric analysis that's making that determination without some kind of human review. Should not be automated, in my opinion. And I think that there could be exclusions set up, for example, using a simple score like a credit score to approve or deny a loan. I think it's reasonable to automate that. But I think there's just too high of a risk of abuse in this context to justify just letting it happen without any kind of a list, an exclusive list of the way things ought to be done. So these automated decisions, again, the problem is that they reinforce cultural biases to solidify normativity within society. And going back to the job interview example, hire view, the way that this works is it just solidifies the culture that you have at your company by finding employees that are similar to the ones that you've already hired or that other companies thought were successful. And it really cancels out the opportunity for diverse voices to be included in corporate culture. And these kinds of technologies are going to become very commonplace, with absent some regulation, very commonplace outside of the context of job interviews, but all over the place. And it's going to create a culture of normativity where there's haves and have-nots. That's going to create a new kind of new forms of cultural exclusion that are just terrible. Now, it's also worth mentioning that in China, they're already doing this. They have a social credit system that takes data from multiple sources about your life and conglomerates that into a credit score. It's like a credit score, but it's actually tied to your identity as a social credit. How good of a citizen are you? And this social credit score can be the sources of data for this could be your social networks, your bank account, your employment information, your credit history, your geolocation information. Virtually all behavioral data that can be collected can be tossed into this kind of system to create a score on how good of a citizen you are. And this is what they do in China. And they use this to justify some very significant decisions, such as your capability to get on an airplane, your capability to get on train systems or buses. People with high scores, they get better interest rates on loans. They get good deals on rental cars. They get specific perks. And what this has created is a more a split of, again, haves and have-nots in the society, and people make very strong choices. They start to realize that the people they're hanging out with, when their cell phone detects that it's near a person with a low social credit score, it actually hurts your social credit score. And so even down to the level of being in proximity of some of your friends who maybe aren't playing the game well, this is a huge problem, and I think that this will be our future if we don't take some steps in the short term to start to put some regulations on how this is used. Next thing, let's see here. Sorry, for those of you who are not listening on YouTube, I have a slideshow, and it looks like I got some of my slides out of order. One moment. Let me find the section on facial recognition software and law enforcement. So what the bill says is state and local agencies shall not use facial recognition technology to engage in ongoing surveillance of specified individuals in public spaces unless such use is in support of law enforcement activities and either A, a court order has been obtained to permit the use of facial recognition services for that ongoing surveillance, or B, where there's an emergency involving imminent danger or risk of death, or a serious physical injury to a person. So I actually think that this is a pretty good standard, and I want to emphasize that I'm highly sensitive to the needs of law enforcement, especially in the context of emergencies. We want to be able to leverage all technological tools available to protect individuals from serious emergencies. Specifically, if you look back to episode 1 of this podcast, I talk about future weapons and the danger of proliferation, widespread proliferation of dangerous weapons, and how we need to use surveillance to counteract that. So I'm very much in support of using surveillance under specific contexts. And I think that these situations, emergencies, and when there's a specific court order that's in context of an already ongoing investigation, I actually think these standards are pretty good. However, I think that, again, there's a narrow scope here that we should be including all biometric identifiers, not just facial recognition technology, kind of future-proof the bill. And we need some specific regulation around mass surveillance, especially at political rallies or protests. And I think that it would be relatively easy for a politician to declare a state of emergency based on some protests going on, and then the police could do a deployment of surveillance systems of cameras with drones or mounted on top of their vehicles and identify all of the people in the protests or in the political rallies, and then use this for making arrests or doing some kind of targeted work against them. And I think that this threat is very real, and it's a unique threat to democracy. And I think that there needs to be some specific protections around that kind of mass surveillance in the political context, and in the context of emergencies, and clarifying what constitutes an emergency. In addition to this, like the corporate scenario, I think there's a risk for a lot of incidental gathering of biometric data by police officers who are using this even when they have a court order. Let's say that they identify somebody in a vehicle and they have passengers in that vehicle. Do they have the capability to run facial recognition on those passengers, even though they're not necessarily implicated in a crime? Can they identify where they are and do some kind of lookups to get information about them or to begin an investigation about them? That's a very important legal question. And actually at the federal level, that's handled by FISA, by the FISA courts, and FISA Section 702. And in a lot of cases, when there's incidental data gathered, what they allow on the federal level, when they're doing international surveillance, for example, is they can actually start investigations about people here in the country when they're if they're having communications with somebody who's under investigation internationally. So this problem of incidental gathering of evidence using biometric data is extremely important, and I'd like to see some clarification around what's the intention here. Another shortcoming is there's a high risk of inaccuracy for facial recognition, which could lead to false convictions. And we saw this happen with DNA technology, where there's case after case after case of people that were thrown into prison, for life or whatever after a murder, and they were innocent, but the DNA evidence, due to misunderstanding within the court systems or within juries, or mix-ups in the labs, or just fundamental problems with the technology itself on the accuracy of the DNA tests, people were put in prison falsely, and we're still processing backlogs of cases where there needs to be review. And I don't want to see that happen with facial recognition or other biometric recognition technologies. I think the risk here is very high because the accuracy of these systems is questionable at best, and this is something that really needs to change. And speaking of inaccuracy, it's actually well understood that the darker a person's skin tone, the less accurate facial recognition algorithms are. So the bill needs some kind of recognition of that problem, and and some kind of way to cope with that, because we already have a Black community that's extremely overrepresented in prisons in Washington, and we don't want to make that problem worse because we're making false convictions because some stupid camera system can't identify a Black person accurately. That would be extremely immoral. Another thing I want to mention here is that I believe that law enforcement who are using biometric identification systems like facial recognition technology, they need special training on those systems, and there need to be standards for how that training is conducted so that investigations are accurate and useful, and so that we're not clogging up the court system with cases that are inaccurate, or we're accidentally collecting evidence illegally and then failing to prosecute people. I mean, this works both ways. Having inaccurate data in the system is bad for prosecuting people who are guilty as well. And that's one thing I really want to point out to people who are in support of law enforcement using facial recognition software. We want to come to I'm very sensitive to the needs of law enforcement personally. And I believe that having more accurate information and being able to make accurate convictions is ethical and necessary. But I want to ensure that the technology is up to that challenge before it's widely thrown out into the wild in some sort of corporate cash feed frenzy, which is the impression that I get of what is going on right now. Speaking of the feeding frenzy, from what I can tell, there's no real specifications for contracting standards or standards surrounding the software that law enforcement are using. The extent to which this kind of stuff is being used in Washington is largely unclear. There needs to be regulation around what happens to the data after law enforcement collects it. Are they allowed to share it with other agencies? Are they allowed to share it with? Are they allowed to take that data and sell it to other corporations or to other states? This is all stuff that really needs to be thought out well in the bill, and it's just not. So again, the solutions, really briefly, we need to include all biometric identification techniques in the bill, not just facial recognition technology. We need to set standards for confidence intervals on the identification process before we're making arrests. And it's important that this happens before arrests are made, because once a person is arrested, whether they're innocent or guilty, they're actually much more likely to be convicted of that crime. And there needs to be supporting evidence. This is something I haven't mentioned before, but there needs to be supporting evidence of a crime being committed, rather that isn't just biometric data. I really think that there needs to be some kind of other evidence before a conviction is made, rather than just algorithmic data due to inherent inaccuracies within the technology. Prosecutors should have the burden of providing additional evidence, not just biometric data. I think there need to be explicit standards in regard to skin tone, the skin tone problem surrounding facial recognition technology and other biometric data. And there needs to be mandatory training for law enforcement that is not only just for using the technology well and being able to gather evidence that's legitimate, and doing that legally, but also around sensitivity to skin tone. And I also believe that there need to be standards on data controllers and processors. So law enforcement and the companies that are doing the facial analysis, there needs to be standards in place on the contracting procedures so that we don't have any opportunity for corruption with another site of corruption within the prison system. So moving on from the facial recognition technology, that was a big conversation. Now we're going to step back out to another issue that I have with the Washington Privacy Act, and that is it does not address the problem of political profiling. And this is one of the areas where I'm less optimistic that changes can be made, but I want to talk about it anyways because it is extremely urgent. first of all, it's important to know that political profiling is widely used in modern elections. I would refer you to a talk by Catherine Tarsany, who's the analytics director at the Democratic National Committee. You can find it on YouTube. It's called How Data is Transforming Politics, from Data Council San Francisco 2019. And in this video, what I learned was that political profiles are made, campaigns, they purchase data, political parties and action committees, they purchase behavioral data from data brokers that's been collected by companies like Facebook or Twitter or Google or whoever. And they do that to build profiles to understand a person's political beliefs. And then they trace that back to identify a person so that they can specifically target an individual for advertising to either get them to go out and vote on election day or to get them to make a donation. And there's a lot of sophisticated technology and mathematics behind identifying people this way. And I believe that this is a legitimate thing to do, personally. And I think that this ought to continue. However, political profiling is a very sensitive area because it poses risks to the fundamental building blocks of how democracy works. For example, political profiling was used by foreign agents who in the 2016 political election, the presidential election, where a very well-equipped Russian operation identified political groups and created targeted social media campaigns for those groups using behavioral data. And they were able to influence the outcome of the election against Hillary Clinton. It's well understood now. And in addition to that, they had the goal of just creating a degeneration of faith in American democracy and in the democratic process in America. And this has led to increased cynicism of the political process and less faith in the Constitution and the way that our government works. And this was an intentional strategy by Russian operatives to create political turmoil within the United States so that Russia can gain a geopolitical advantage over the United States in the future. And this is a very intentional strategy that was executed, unfortunately, very well and continues to this day. And political profiling is the cornerstone of this technology. The Russians and other agents have been able to amp up bipartisanship in the United States by creating false social media profiles, both on the left and the right. And I want to emphasize that this was not just, Twitter accounts that were supporting Donald Trump. It was also Facebook groups and all kinds of there was targeted campaigns against the left as well to amp up hatred of the right. And on vice versa, there were campaigns by Russian operatives targeted at the right to make them hate the left more. And that continues to this day. And I believe that this could undermine the political processes that we have in place so that we can have civil resolution to political conflicts in this country. And I think that it's very dangerous to allow this to continue. And it's a fundamental risk to democracy in the United States, as well as puts us at a geopolitical disadvantage to other countries that have a stronger political process and a more unified electoral body. In addition, I think that if this continues, it will lead to significant political turmoil. You can see conversations about that already with Donald Trump retweeting recently. Again, we're in October 2019, recently retweeting from political commentators who are saying that if Donald Trump is indicted or if he is impeached, that it would justify a civil war. And I think that if we allow political profiling to continue, unregulated, that this kind of amplification will continue to increase. Furthermore, another huge risk of political profiling is what is called turnkey totalitarianism. And this is where a dictator seizes control over political profile data, and then they use that to target their opposition, to silence them in the context of an election, or maybe with violence, or by whatever means are politically feasible at that point in time. So a scenario that could happen is President of the United States creates a state of emergency, and then using that power, they seize political profile data to target their opposition, to take some kind of action against them. And I think that this is a very real threat. And even though this is just Washington state legislation, as the bill states, the kinds of standards that we set for whether we are going to allow this kind of thing to happen will trickle up to the national level, or that's the hope. So I think that we should address it in our bill. So the solution here is regarding political profiling is that data processors, first of all, they need to be held liable for processing data on behalf of foreign controllers. So when Facebook crunches numbers and identifies liberals that the Russian operatives can target on their Facebook ads and in their Facebook groups, Facebook needs to be on the hook for that, for example. Political profiling, I believe it should be illegal. Again, I don't have the legal expertise to say whether this is feasible or not, but in a perfect world, I believe political profiling should be absolutely illegal, except in the context of legitimate political campaigns who are out there trying to win elections and trying to gain voters. I believe those are really the only organizations who should be allowed to perform political profiling. And lastly, another solution I'm proposing is that there ought to be explicit regulation of access to political profile data for government officials. So the problem is, once this data is out here, even if it were to be restrained just to political campaigns, once that data exists, unfortunately, it can be difficult to regulate who has access to that data. But I think there should be some attempt made to specifically forbid government officials from accessing and using that kind of data for personal gain. That wraps up my problems and solutions, I believe, for the Washington Privacy Act. And one of the last things I want to do here is address one of the common concerns about placing regulation in general, but especially on technology, which is, will privacy regulation restrain innovation? And if we think about an example of a fully automated grocery store, an extreme example of innovation, like a grocery store with no employees, where it's completely run by robots and people walk in, grab the groceries that they want, and they walk out and they get charged directly through their bank account or credit card or whatever. We've seen Amazon set stuff like this up in Seattle, for example, in an experimental manner. But we can think about an extreme example of innovation like that. And if we think about this example, there's absolutely no reason why protecting a person's privacy would make that kind of store less effective or less friendly to use. There's absolutely no reason why the grocery store needs to know your specific behavior within that store while you're shopping around, or to tie that information to your identity itself, to your name. There's absolutely no reason why they can't create robots that stock the shelves effectively. There's no privacy concern with that kind of technology. There's no privacy concern surrounding having automated cash registers where people check themselves out, or even where the items are scanned somehow automatically as you walk out the door. As long as the person is carrying some kind of identification card that they choose to carry with them, that they can scan on their way out the door or whatever, there's absolutely no reason why a company would need to use facial recognition technology to charge the person for the groceries as they walk out of the store. I can't think of any compelling reason why there needs to be privacy infringements in order to make this kind of extremely innovative technology work very well. So that's just one example. Of course, there are many, and there are certainly examples where there are conflicts between privacy regulation and innovation. However, I believe that the price of losing privacy, as I mentioned earlier, is extremely high, and so it's worth protecting even in the context of restraining some forms of innovation. Another area where I don't think there will be very much restraint is where consumers interface with companies digitally. For example, if I want to have a Skype call with my doctor, there's no reason why there needs to be somebody in the middle identifying me, listening in on that call, hearing what I have to say with my doctor about what medications I'm taking or not taking, whatever health problems I've had. I don't need a company in the middle that's analyzing that data and then selling it to my insurance company. The innovation is on the side of the way that I communicate with my doctor. It's not on the side of capturing that information and selling it to somebody else for their own exploitive purposes. And so the kinds of innovation that we want to promote actually do not run contrary to personal privacy. In fact, they support personal privacy, and they support personal convenience and personal empowerment, which is the most important thing. Another thing is that consumers prefer to buy products that have privacy features built in. There's a huge rise. I don't have the evidence specifically in this slideshow to tell you specifically what the numbers are, but I know that privacy features are a big selling point for companies today, specifically Apple, in the Apple versus Android debate of the smartphones, which is a huge marketplace. The privacy features that Apple offers are a big selling point for that company, and it does bring them a lot of business. And so, but at the same time, we can't let the free market, we can't let consumers make that decision, because a lot of the consumers are going to have imperfect information about what kind of privacy they're giving up due to the way that consent contracts are formed by accepting agreements by touching a button. Consumers don't understand the kind of information that they're giving up to corporations today. And even if they did, in a lot of cases, the convenience or oftentimes the necessity of having access to those services is extreme enough that they're being coerced into giving up their privacy for no real gain to themselves, only so that their behavioral data can be captured and resold, and so that their identity can be exploited for the profit of large companies. And I feel like that's immoral. And I feel like consumers naturally prefer products that don't do that. And that given the opportunity to have that kind of legislation, most consumers would prefer to have that in place. The last thing is that many algorithms are equally effective when data is anonymized. So for example, using a service like Google Maps, I want to check the traffic before I leave to go to the other side of town or to drive to a different suburb or whatever, because I want to make sure I'm not going to get stuck in traffic. There's no reason why Google needs to know the identity of the people who are driving the cars and track their movements and sell that information to companies so that they can give them ads based on where a person goes. There's no reason that a map needs to be able to track the person's identity. They only need to know that a person is driving from point A to point B to calculate the traffic. And that's just one example where anonymizing the data doesn't undermine the innovation of the technology itself. It only eliminates the opportunity for these corporations to exploit their consumers. And so this is a really important point, and I think it applies in many contexts. And just to reiterate, I believe that even in cases where the price is high, where we are giving up a certain kind of innovation, the right to privacy is something that's worth defending, even in that context. Last, I want to wrap up this conversation in a very big picture manner, which if you can't tell yet, I really like looking at the big picture. And I want to return to Shoshana Zuboff, who wrote The Age of Surveillance Capitalism, which was released in 2019, who's had a tremendous influence on me and my beliefs about surveillance and privacy. And a quote from her book that I really think summarizes her message is this: "We worry about companies that amass our personal data, and we wonder why they should profit. Who owns the data, we ask. But for every discussion of data protection or data ownership, it always omits the most important question of all. Why is our experience rendered as behavioral data in the first place?" With that, I would like to thank everyone for listening, and hopefully this inspires some deep thought. Please feel free to reach out to me if you have questions about this material, or if you'd like me to appear on your podcast or other interview or at a local meetup. I'm happy to do that. And with that, I hope that you have an awesome day. The best way to support this podcast is to like and leave comments, as well as share the episode with your friends and colleagues. You can find detailed notes, reading suggestions, and a complete episode list at bigdatabigissues.com.